Hello, everyone, and welcome. My name is Mitchell Zutto. I'm the Managing Principal at Sharrock, Pitman Legal, and thank you very much for joining us for our webinar today on dealing with commercial leasing, part 2, following on from our webinar earlier in the year on this topic. So before we get started, we'd like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. Whether you have joined us for our webinars before or if it's your first time, a very warm welcome. We hope these webinars are a helpful resource for you, an opportunity for us to share with you some must-know information and guidance on different topics that we think may be of interest for you. And you can catch up with the recordings and slides from our previous webinars by going to our website and clicking the link for our resources page. And there you'll find all our previous webinars from our lawyers on issues in commercial and business law, disputes, estate planning, employment law, and of course, property law, including our previous webinar on leasing. Today, we're going to continue looking at commercial leases and more specifically, some of the key things you need to know about different types of leases and different types of business premises. And as we said before, this is an area that may seem simple on the surface, but there is a lot of information around and also a lot of options. So it's important to get to the bottom of what you need to know for your own particular situation and premises, both in terms of what suits you best commercially and in terms of your legal compliance. And that goes whether you're a tenant of premises or a landlord. So we hope today that we can give you some more good handles on the things that you need to know. So I'll shortly hand over to Andre Ong, who will take us through today's content. Andre is my fellow principal here at Sharrock, Pitman Legal, and an accredited specialist in property law. And he has many years of experience in this area, of course, and is an expert in the field. So I know he's looking forward to sharing his knowledge with you today, as are Shubha, Ignatius, Crystal and Rebecca from our property team, each taking you through some different aspects through the session. Before we begin, just a couple of housekeeping items. We're in webinar mode, obviously, so your cameras aren't visible, don't worry. And we are recording the session, so it'll be available on our website and YouTube page soon. So if there's anything you miss, you'll be able to catch up with that later on. If you have any questions through the session, please feel free to type away in the Q&A box at the bottom on your screen. We might try to cover questions as we go along, but we've also set aside some time at the end. If we do run out of time, and we are conscious of your time, of course, if we aren't able to get to all of the questions, don't worry, we will make a note of those and get back to you afterwards if we need to. And final piece of housekeeping before we begin, we are lawyers after all, so we do need to put up some fine print. Needless to say, we can only give you some general guidance in this session. All circumstances and landlords and tenants and premises are different, so that's really important to keep in mind as you're listening to the information today, and make sure you do get specific advice on your own situation before doing anything. And with today's topic in particular, it's really important to keep in mind that this is based on the law as it stands here in Victoria, particularly when we're talking about things like the Retail Leases Act. So let's get started. Hand over to Andre now. He'll start taking us through what we're going to cover today. Thank you, Andre.
Thank you very much, Mitch. So there's a bit of a session overview there. I'd like to, if you haven't seen the first webinar, it's up on our website. That went through a lot more of the general aspects of leasing, but in terms of today and the tips and traps, it's really a matter of the fact that your premises matters, that the individual nature of your premises and the individual nature of the tenant that you're dealing with, or vice versa, the landlord that you're dealing with, makes a difference in terms of the document that's got to be prepared, the commercial terms and legal terms that you're agreeing to make sure that everyone's going to come up with the best commercial and legal outcome. So in terms of what we're going through today, Rebecca Worcester will start off in terms of running through a few issues that are specific to retail shopping centres, nature of disclosure, situation-specific issues and considerations there from, again, tenant and landlord perspective. Then Crystal Roman will follow up in terms of licensed premises, being things like restaurants, pubs, etc., childcare premises, but also generally any kind of premises where the business that's operating within it requires a license from, say, government authority in order to operate, followed by then Shubha Rao, who'll run through issues that are we've been running into in terms of the office space, where people are leasing within an office building or office context for a commercial office use. What are the issues coming up there that you've got to have some awareness of? And then following through with Ignatius Suwanto in terms of industrial space. We've been certainly doing a lot of that of late, and there's a lot specific there in terms of the new construction that's happening on the fringes, or sometimes not so fringes, of Melbourne anymore. There's a lot that's going on there, and lots of agreement to lease issues, as well as operational issues in factory and industrial premises that you have to be aware of. The main thing is, when you're looking at your lease, just relying on those generic terms can cost you. So it's important to be tailoring things to your specific circumstance, to the specific risks of the operations that are going to be happening in the premises, to make sure that you're covered off, and that unexpected things, to the extent you can control them, are going to be properly addressed within contingencies in the lease. Finally, within that context, also thinking about these leases across their lifetime in those different industry areas, because ultimately you've got those different considerations depending on where in the lease that you're at, and from a landlord perspective, how that might be traveling along within transfer of lease context, for example. So I will hand off initially to Rebecca, and then I'll see you for the Q&A afterwards. Rebecca.
Thank you, Andre. So leases for shops located within retail shopping centres encounter matters that are not typically faced by retail tenants in other locations, such as street front shops, because they are independently owned. So the Retail Leases Act generally covers retail shops within shopping centres and defines retail shopping centres by assigning it specific classifying attributes. So the Act's definition says that a retail shopping centre must be a cluster of premises where there are at least 5 premises that are retail. The premises must all be owned by the same person, or at least have the same landlord or head landlord. They must be located in a single building or 2 or more buildings that are adjoined or separated only by common areas or by a road. And the cluster of the premises must be promoted as or regarded as constituting a shopping centre. So one of the major differences for retail shopping centre leases is the requirement for a landlord to provide the prospective tenant with a disclosure statement specific for shopping centres. And in addition to the standard retail disclosure matters, the retail shopping centre disclosure form provides further requirements that have to be disclosed. So one of those is whether the rent is to be calculated on turnover, which is quite common in shopping centre leases, as opposed to a standard rent amount. Also, that there are further details for outgoings. So, for example, relating to customer facilities within the shopping centre, such as lifts or elevators. Also for customer information services and the centre outgoings itself. There are also disclosure requirements for the costs for advertising and promotion of the centre, for the core trading hours of the centre, details of the shopping centre itself, so including the number of shops and the annual turnover of the centre. And then details of major tenants such as supermarkets or department stores and their lease expiry dates. You need to include the floor plan showing the tenancy mix and disclose whether the landlord assures the tenant that the mix will not be altered by the introduction of competitors. Another disclosure for customer traffic flow information, if that is collected by the shopping centre, and whether the casual mall licensing code of practice is adhered to for the common areas. And the appropriate form is in Schedule 2 of the Act, and it should be provided in accordance with the Act just to ensure the validity of the lease itself. And then there are quite a few matters that are specific to retail shopping centre leases that should be considered. The Retail Leases Act includes further landlord requirements for shopping centre leases that must be adhered to in addition to the standard requirements of a retail lease. So one of these is that the core trading hours of the shopping centre cannot be changed by the landlord unless they have prior consent of a majority of the tenants of the centre. Another one relates to advertising, where tenants cannot be forced by the landlord to advertise their own business, but if the parties agree, the landlord may advertise and promote the shopping centre and then claim costs from the tenants as an outgoing. And if they do so, the landlord must provide the tenant with a written statement detailing the expenditure for the advertising, along with a marketing plan. It's not uncommon for shopping centres to undertake alterations, and as such, the lease should include clauses relating to the alterations, and that should be carefully considered. So the Act requires a landlord to provide a retail tenant notice of any refurbishment or alteration, and the landlord cannot begin works which would adversely affect the tenant's business unless they provided them with a written notice to the tenants of the works, and this must typically be given with a minimum of 60 days prior to the commencement of the works. Typically, a relocation clause will be included in a shopping centre lease, which will allow the landlord to relocate the tenant to a comparable alternative premises in the centre, should they wish to, for example, extend or rebuild, develop the shopping centre at all. So the clause should be carefully drafted to comply with the Retail Leases Act, including those notice requirements, but it should also be consistent across all of the leases in the centre to ensure that the different tenants can be dealt with by the landlord in a similar way, so that they can be relocated and so that that construction can actually be undertaken. Another specific issue is in regards to make good obligations. So retail lease landlords cannot recover capital costs from tenants, but the lease can be written to require tenants to carry out capital works at their own expense or in respect of any essential safety measure, or an installation relating to a fit out of the retail premises for which the tenant has agreed to pay. So, for example, in shopping centre leases can be written to require a tenant to construct their shop front or install roller shutters at their own expense, and then require them to leave that at the end of the lease. Landlords also often contribute to the fit out work cost while specifying that what they've contributed for remains their belongings, but also that it has to be removed by the tenant at the end of the lease. Landlords would also benefit from clauses that have the make good works completed before the expiry of the lease, and charge the tenant for the make good period, or allow the removal and storage of their goods at the tenant's expense, because this ensures the shops are not left unleased and empty for periods of time, which would minimise the trading environment of the shopping centre, and then with the rent received from other tenants as well. I'll now pass it to Crystal to discuss her matters. Thank you.
Thank you, Rebecca. So now I'll talk about leasing of licensed premises and also childcare premises. Starting off with the licensed premises, by way of context, licenses can include liquor licenses for places such as restaurants, nightclubs, bars, and also things such as, for example, skin piercing licenses. And these would be tattoo parlors, piercing shops, even beauty parlors as well. So there are a few considerations to take into account when you're drafting a lease or negotiating the terms of a lease in relation to a licensing clause. In particular, it's important for both tenants and landlords to negotiate a clause conditional on the tenant obtaining a required license. The last thing either party wants is to enter into a lease where a license is required and ending up stuck in a lease where a license is unable to be obtained. For this reason, we recommend that parties think about these 4 considerations. Firstly, have the lease conditional on obtaining the required licenses by a specified due date, and record any ability for an extension of the approval date. So this is extremely important as it provides both parties with the deadline and structure moving forward. Second thing to think about, can the premises operate in any way whilst the license application's in the works? So this is reviewed and questioned on a case-by-case basis, where depending on the type of business, the business may operate on some level without the license. For example, think about a deli that also sells alcohol, but it also sells other food and products as well. So it might still be able to operate its business to the extent that it does not sell alcohol. Another example that we've also encountered is storing and making wine. For example, a business can store wine without having to require a license, but it will need to have a license to make the wine. So it can store the wine in the meantime. So this would be different from, say, a bar or a nightclub that most likely wouldn't be able to operate through that time. If the business can continue its operations, it might be in the best interest of both landlord and tenant, of course, depending on the individual circumstances. The third thing to take into consideration when drafting a licensing clause is what happens to the license after the termination of the lease. Is it suitable that the tenant transfer the license to the landlord or any other subsequent tenant that the landlord nominates at the expiry of the lease? For example, a landlord may want to negotiate this in the lease if the premises would commonly be used for a bar, and transferring the liquor license to a new tenant could mean that the commencement date would be earlier rather than later. Last consideration is what happens if the license isn't approved by the due date or by any extension of the due date. So this is a really important question to ask, and it's something that really needs to be set out clearly in the lease. So we've just drafted and negotiated terms from both landlord and tenant's perspectives on this. As a tenant, you would obviously want to ensure that you can terminate the lease with no strings attached. That is, the termination occurs simply because the license was not issued by the approval date, and there are no further obligations required apart from your general make good. From the landlord's perspective, if the premises hasn't been used for months while the tenant is waiting their license approval, it would obviously be in the best interest for the landlord to recover some sort of payment. For example, it may be suitable as landlord to request something that could be described as a lease deposit, being, for example, 2 months of lease rents worth at the commencement date or at the date that the lease is signed, and which this can be forfeited to the landlord in the event that the license isn't approved. And thereby, in the event that it is approved, the lease deposit is applied towards the rent for those 2 months. Obviously, this favours the landlord, but we've seen tenants agree to this in the past on the basis that it will be applied to the rent. So these 4 points are your starting place when considering leasing a licensed premises. It's extremely important that your special condition touches on these factors as it provides a proper structure and certainty for all parties. Now, moving on to childcare leases. So I'll briefly touch on childcare leases as they're generally a more niche type of arrangement. So carrying on with licenses, the main issue that should be considered in a childcare lease is how is the rent applied in childcare? By way of background, the rent for a childcare premises is calculated on the amount of places. That is, 1 place equals 1 child. And if 1 child, let's say, for example, equals $3,000 per child, that means that if a venue or a premises will allow 100 children, you'll have around $300,000 of rent per year. So the key question is whether the rent is applied on one of the following. That is, the amount of places permitted under the planning permit, or the amount of places permitted under the direction of the Department of Education and Training, or the amount of places available at the time as the tenant directs. For example, if the planning permit allows 100 places in total, the department allows 90 places in total, and the tenant wants only a total of 80 places, how is the rent calculated? The lease needs to be extremely specific about this, and the rent clause should record the amount of places as determined by the relevant authority. This will alleviate a lot of uncertainty in the future. Now, moving on to a second consideration for childcare premises. This is the 15-year exemption rule. So this is one of the most important factors in childcare leases, and it's to do with the duration of the initial term. Due to the nature of a child care centre, that is, being tenants want a long-term lease, it is common that the initial term of the lease can be 15 years long, and then obviously with options to renew that follow. We find that this is where tenants may fall into a trap, being unaware of one simple exemption to the Retail Leases Act, which is the 15-year term exemption. In short, this exemption refers to a lease where the Retail Leases Act generally applies, such as a childcare, but where the initial term of the lease is a term of at least 15 years, and where one of the following apply. Firstly, the lease imposes an obligation on the tenant or any other person to carry out substantial work on the premises, and can involve building, installing, repairing, or maintaining any structure or fixture in the premises. And this is actually usually done in childcare leases, as the tenant may install fittings and fixtures required. Mitchell, if you can go to the next slide, please. Or the second obligation is that the lease imposes an obligation on the tenant or any other person to pay any substantial amount in respect of the cost of any of the works, or the lease does not permit the tenant or any other person to remove any of the works at any time after the initial term of the lease. So in short, landlords of childcare leases may seek to have the Act not apply by passing on the substantial work obligations to the tenant on structures, fixtures, and plant and equipment. But remember, only one of these three is required. The obvious effects of the lease no longer being a retail lease means that the landlord can then request that the tenant pay for outgoings that the Act would otherwise not permit, such as land tax, and pay for capital improvements to the premises. It would also mean that other general protection that tenants are given under the Retail Leases Act would no longer apply. It's therefore important that tenants are aware of this exemption if they are signing onto a 15-year or more childcare lease, and a tenant may then want to possibly sign on to a 12-year lease, for example. I'll pass it on to Shubha now.
Thanks, Crystal. Good morning, everyone. So I'm here to just give some tips on negotiating leases for office premises. So just a few general points that we've come across in recent times. With the permitted use, normally for offices, it just used to be just the word office that would get specified, or commercial office and so on. But now we're seeing a lot more in terms of restrictions on the type of office that's there, whether it's a legal services firm, an accounting services firm, or a financial planning business and so on. So some landlords are putting these further restrictions in the permitted use section. So depending on whether you're a landlord or a tenant, you might want to either negotiate to broaden the permitted use or to narrow it, so that when the transfer of lease needs to occur, a more restricted permitted use will then allow a landlord ability to be able to not consent to a transfer at a later stage. So as a tenant, a broader use would definitely be more applicable. It's also in terms of a shopping center premises, as Rebecca has discussed the definition of it, where the office is located. If you're located within the first 3 levels, then the Retail Leases Act will apply. If you happen to be above the 3rd level, then the Retail Leases Act is actually exempted from the application. And so then land tax outgoings may also be charged to a tenant. So that is definitely something that needs to be looked out for. One of the other ones that we've seen in terms of offices is refurbishment and repainting requirements. Generally with offices, you don't expect too much refurbishment that needs to occur at the expiry of the lease. We have had a client where the landlord was actually seeking repainting works for some scuff marks on the walls, and so on. So as a tenant, you might want to seek to extend the requirements for repainting. Normally in the leases, they have a 5 or 6 year time period where you're required to repaint or refurbish the premises. As a tenant, you might want to push out that time frame. As a landlord, you might want to try and keep to the standard time frame that's there. Also, the other point is make good obligations at the end of the lease, and how fair wear and tear applies to this. We've actually had a client where there's been a dispute with the landlord because in the office premises, there was just, general office furniture, and the office furniture has created small little dents in the carpets, and the landlord was indicating that this was damage to the carpet by the tenant, and was requesting replacement of the whole carpet for the area. For our tenant client, we went to bat for them, and we were saying that these were fair wear and tear, and they're general, what you would expect in an office, and the carpet was actually not damaged. So if these things can actually be addressed at the time of negotiation, that might be better, so it doesn't arise in a dispute at the expiry of the lease term. Also, responsibility for water ingress. We're seeing quite a few of these matters pop up where with the changes in weather and heavy rains that we're getting, there's been quite a few leaks in office premises. So it is the landlord's responsibility to be able to make sure a premises is watertight. The tenant does need to identify such leaks or staining on the ceilings to the landlord as soon as possible, and the landlord needs to attend to those leaks. We did have a case where a client actually went to VSBC mediation as well, where the leakage was such that the ceiling tile had actually bulged and had then broken down and actually the ceiling tile had fallen onto the desk of the client in one of the offices that she had. So that's probably an extreme case, but it's also if there's neglect by the landlord for not dealing with the leak, it can lead to further issues, and a tenant can seek rent abatement as well because they're not able to use the premises. The last point that we've seen also is the ratchet clause. So if the retail lease doesn't apply, landlords can actually seek for a ratchet clause to be included, which would mean that rent cannot drop below, at a time the rent gets reviewed, rent cannot drop below what the current rental was for the previous year. And so that's a good thing for a landlord to have in there, especially in this current climate. So the other types of office premises we're seeing, I guess, is where there are shared workspaces. So there's multiple businesses on one premises. The way we can see this, like, for example, a Regus is such where they sort of let you have licenses to premises where you come on for a couple of hours in a day, and you pick and choose how you want to actually use the premises. So that's a big, broad way of doing it. We've also seen some businesses where, 4 or 5 people want to take on a lease together for one large premises and to share the whole workspace. So how would that sort of work? You can either have 1 or 2 people go on the main lease with the head landlord and then do subleases to the other businesses. Or, you can have all 5 people go on for the lease with the head landlord. And then if they do have other workspaces which they're willing to share, then they can do subleases or licenses. In the circumstance that, say, 3 or 4 people actually go on the head lease, if there are workspaces that actually cannot be specified to each business, if one of the business then wants to sell their business to another person, it becomes a little bit difficult if they don't want to actually change the head lease. You might have to then do a sublease to the new business that's coming on. But it might mean that the outgoing tenant who's selling the business might still be on the head lease as a guarantor because the head lease is actually not changing. So there's a few considerations that need to happen when there are multiple businesses going into a lease with a head landlord. So it is kind of 50-50 as to how people are doing it, whether they're doing it as to one person goes in and then subleases or licenses the rest of the premises to other businesses, or whether 3 or 4 people are going into the head lease there. Next one, Mitchell. And also, we've also got the premises where if there's one business that has, taken an initial lease of a premises and subsequently it's grown to a huge size and they need to expand their premises. There might be goodwill in the current location of the premises such that they don't actually want to move. And so what options would such a business have? So they'd have to look at what suites are available around the business and to see if they can actually use that and expand into those suites. So one of the things that would definitely need to be considered with that is whether you can get alignment of lease terms and options for the second suite that they might want to expand into, to ensure that there's continuity for the business as a whole. You wouldn't want to start a second lease for the next suite and then have the landlord later on not then grant further extensions, if it's an initial shorter lease period that's provided to you. So definitely there needs to be an alignment of those terms and options. And if you're able to secure the premises next to you, then what sort of fit outs do you actually need? It might need to be that both premises need to get revamped so that there's a bit of better flow in the office workspace, or different conference rooms put in and so on. So then you got to ensure that the fit outs are acceptable to both landlords and what requirements they might have with respect to their fit out requirements there. And if possible, try and keep the fit outs within each of the premises, so there's no overlap between them. Part of the that fit out and new flow would mean that, you know, separation walls might need to be removed as well between the two premises. And landlords would actually need to be acceptable of that as well. And what happens on reinstatement when the lease is expired, whether the landlord would then, the two landlords would then require that, okay, both leases can be offered, say on a transfer of lease to another premises, but not another tenant coming in. But if they don't want both suites and so on, then you have to reinstate any walls that have come down between the premises there. And again, even with this one, you know, guarantors are always important there. If one landlord requires more guarantors than another one, and so on. So those are also terms that need to be negotiated with landlords and things like that. So generally, this is what we're seeing in terms of office premises that are being negotiated, leases for office premises being negotiated recently. I'll pass you on now to Ignatius.
Thanks, Shubha. Now we'll walk through the tips and traps for factories and warehouses. And the first and probably the more important traps is to consider whether the premises is a retail or non-retail lease. By way of recap from our previous property law webinar, a commercial lease can be a retail or non-retail lease. The two key tests to determine is first, the ultimate consumer test. Are the persons who use the services from the tenants the ultimate consumer? And the second test is the open to public test, whether the public can have access to the premises and what type of access or supervision applies to the public. Now, why am I touching base on the retail and non-retail lease in this section? It is because it is important to understand that the cases that determine the test actually comes from factories and warehouse. In the ultimate consumer test, the case in question is the CB cold storage case, which involves a premises for cold and cool storage warehouse and transport facility. And the second bit, for the open to public test, the leading case is called the bulk powder case, which involves a premises for the production, packaging, and storage of health supplements. Therefore, it is to say that the determination of retail on retail lease in factories and warehouse are important, and it can be tricky at some cases because it really depends on case-to-case basis. And it is also important to remember why the distinction is important is because of the recovery of some outgoings are prohibited by the Retail Lease Act, such as the recovery of the land tax, which is getting higher and higher. And considering it is an industrial land, the value of the land tax could be quite substantial in this case. Next, I will be touching base on the circumstances in which the landlord and the tenant wants to agree for a lease for the landlord to construct the warehouse or the factories for the tenants. This can be done by way an agreement for lease, in which the parties agree that there will be a lease signed under the agreement for lease, which will commence at the completion of the building. Now, in drafting an agreement for lease, it is important to consider whether the factory or warehouse is specifically built for the tenants. If it is the case, it is important to include all the applicable building plan and building specifications to ensure that the parties understand that the buildings, what the parties agree for the building to be built to be substantially the same as the end result. And next, it is also important to understand that because it is not built yet, there might be changes to the plans and specification. So it is usual that there will be alterations to any plans and specifications as required by any governmental or other body to comply with the legal obligations of the builder in the construction of the building. Otherwise, it will be hard or impossible to get the necessary approval. In discussing the rent adjustment, it is important to agree on what are the acceptable limits in the variance in the size, whether 5%, 10% changes in the area is acceptable to tenants. And second is whether the rent will be adjusted in accordance whether the building is bigger or smaller. Next is also important to consider the timeline for construction, as the tenant entered into this kind of agreement in expectation that they will have the premises at certain dates. So it is important to consider whether there will be a sunset date in the agreement for lease, in which after that date, the tenant can choose to terminate the agreement for lease and move elsewhere. And next bit is for the defects prior to the commencement of the lease, which is very unique to agreement for lease type, because usually in a commercial lease, the tenant will accept the property as is, and the party will have a condition report on the commencement of the lease. But as the premises is specifically built for the tenant, it is brand new, and therefore the landlord and the tenant can negotiate on the defects liability period, in which the tenant can notify the landlord to repair the damages to the property due to the construction. We see sometimes that the landlord wishes to have the defects liability period between 1 to 3 months, and the tenants want a bit more from 6 to 1 year. So it is a commercial negotiation at this point on whether what is the appropriate defects liability period for the warehouse. Next, just a quick touch base on option to purchase the premises, as we can observe that it is getting requested more by the tenants to purchase the property during the time of the lease, or during certain period from the commencement of the lease, that they have the option to buy the premises from the landlord. And sometimes we can see that the landlord agrees in order to lock the deals. So if you are going to grant or agree to an option to purchase the premise, it is important to lock in the key terms for the options, such as the sale price for the property, as well as the conditions for the trigger for the options. For example, the tenants can only exercise the option if they are not in default of the current lease. For next, I will discuss the specific requirements for factories and warehouse. First, and probably most important, is the power usage, is to ensure that the power for the plant and equipment in the property is sufficient, because like in factories, you might need a higher power capacity, and it is important to have this discussion with the landlord to ensure that there is sufficient power capacity and voltage droppage in the premises. If the current premises do not have sufficient power capacity, the tenant and the landlord can negotiate on whether the landlord will do the upgrade works prior to the commencement of the lease, or whether the tenant can, at their cost, do the works. And the second bit is to consider the noise level for the permitted activities in the premises. This is especially important if the tenant hires only part of the building, not the whole building, as it might impact the landlord's ability to hire the other premises if the current tenant is using it for something that have a high noise level. It's also important to consider the council restriction on this matter, as there is a limit on the noise depending on the zoning of the premises. And thirdly is the installation of specific equipment to the premises, which usually is not a problem in a lease, but in these circumstances, installation of equipment could involve installation of crane beams, which could support very heavy cranes. So it is important to consider whether the premises could support the installation of these equipments. And the last issue that I would like to touch on is on the repair and make good for factories and warehouse, which is a bit different from the usual lease, because the nature of the tenant installation in the premises are different. For example, for a warehouse, the tenant might install racking or shelving units with dyna bolts, which means that the shelving units are secured to the concrete floor. In this case, it is important to have a discussion on whether the tenant is required to remove the shelving unit at the end of the lease, and whether they have to manually angle grind the dyno bolts to ensure that everything is back to the initial condition, or whether the landlord will accept the surrender of the shelving units as a landlord properties at the end of the lease. This might be beneficial for the landlord if they want to keep using the premises for warehouse for the next tenant. The next issue is concrete discoloration on whether the tenant is required to restore the concrete to the original color. And lastly is to consider if there's any damage to the properties due to use or the removal of the equipment. And it is important because, like, again, the plant and equipment is substantial. Whether the damage will have overall impact on the structural integrity of the factories and the warehouse, and just to ensure that the make good is not a band-aid solution that will impact the premises in the future. Now I will pass the time back to Andre.
All right, thank you very much for that, Ignatius. So now's the time for some questions. If anyone has any, please input them into the Q&A or chat buttons on your Zoom screen. Just pending those questions coming through, I just thought I'd add some bits and clarify some bits with all of the information that you've just heard, effectively in the same order that we've run through it. So starting with the shopping centre side of things, just be aware that a shopping centre as defined in the Retail Leases Act isn't necessarily what you'd expect a shopping centre to look like or be. It's essentially any 5 premises that are together or next to each other with common areas in the middle. It could be 5 shops in a row that just happen to be owned by that one person or one entity. And in that situation, you still have to comply with the additional shopping centre disclosure obligations in the Retail Leases Act, even though you wouldn't expect that to be a shopping centre in the ordinary sense. Oh, hang on, we've got our first question. How do you determine tenant and lessor installations when the lease is not specific and there's a dispute as to who owns what and the landlord wants items removed at the end of the lease? Ultimately, Joel, that comes down to what evidence we have as to what was in place at the outset. This can often be an issue in terms of where a landlord has taken over a premises that maybe they've had to terminate the previous lease, or there was an abandonment by the previous tenant of some goods or installations. Who do those, maybe it's an alarm system, maybe it's air conditioning even, who do those items belong to? Is it something for the new tenant to then resolve afterwards? Ultimately, if the previous tenant had abandoned things and they would become the landlord's property once the landlord retook possession of the premises and that previous tenant didn't make any claim on those goods. And ultimately, then when you lease it further, if the lease hasn't been clear as to the fact that those installations now pass on to the tenant, because as landlord, you might want those installations to be cleared by the tenant at the end, they're of, say, no value to the landlord, especially if we're talking maybe a generic sort of phone, an old phone system or an alarm system, you're going to want to make that specific, because otherwise the default scenario is going to be whatever was there at the beginning, which wasn't installed by the tenant, is going to be treated as a landlord installation, even though from the landlord's perspective, it may have been abandoned there by a previous tenant. There's a little bit of gray area here in terms of things that don't fit within that fixture definition. So an alarm system, an air conditioning unit, something that's fixed into the building, easier to argue is a landlord installation because it's a fixture of the building, it's part of the building. We often run into scenarios where an office lease has been terminated and there are desks, chairs, that are just left there from the landlord's perspective. They don't care. The new tenant comes in, they can use those. But the issue obviously is the landlord doesn't want to take responsibility for those items. So it is important to be clear that those items will become the tenant's obligation. And you might, if you're the landlord, say there are workstations that might have been customized into the premises, you might want to write in the lease to be able to force the tenant, even if you're transferring ownership and responsibility for them in the lease, you might want to be able to.
Andre's frozen up, but just see if Andre gets back online.
The example that Shubha raised earlier with dents in carpets and that sort of thing. We have seen some leases with clauses that require chair mats to be used by the tenant. So that might be one way to practically address that sort of an issue. When we've got another question in terms of if there's money owed to the landlord at the end of lease, can the landlord withhold this from the bond or the security deposit? And the answer is yes. Ultimately, that's what the security deposit is for. The key issue is going to be obviously what money is owed. In terms of rent, outgoings, those direct obligations, yes, that can be taken from the security deposit. Similarly, if there are make good items that are outstanding or in dispute, again, that can be drawn from the security deposit. Obviously, if they're in dispute, there's a risk level there if the tenant wants to take action and report that the make good item wasn't maybe covered as an obligation under the lease. So yeah, you got to be careful about that side of things. But in a general sense, it's effectively the broader loss that a landlord's going to suffer from a lease that they can draw directly from that security. It's why it's there. I've got another question. What happens if the landlord just bought the fifth property in a shopping strip to the existing lease? So yeah, that obviously creates an issue in terms of something that they had 4 out of 5, so it wasn't defined as a retail shopping center. They now bought the fifth, so it becomes a retail shopping center. There's no black and white answer to that, as in I'm not familiar with any specific case at VCAT or courts that have run through it. However, there have been other cases where basically whatever the status of the lease was at the point of entry or at the point it was agreed, it tends to work one way only, as in if something was in the act, as in the lease was subject to the act at its point of entry, it's not really supposed to fall out of the act by the operation of something that's occurred in the middle, and vice versa. The only point at which those conditions change tend to be at the next point of renewal or the an options exercise, maybe a new lease is entered into. At that point, then the fifth premises having been acquired, I'd expect the retail leases, shopping center obligations, disclosure obligations then kick in. So I wouldn't expect there to be a problem with the other 4 existing premises where you hadn't complied with the shopping center obligations, and then you bought the fifth one and suddenly that's come in. Now, those cases I'm referring to are revolving around rent review, basically provisions where there have been an occupancy level, because basically you fall out of the act if you have an occupancy cost of $1 million or more. So there have been some cases where tenants have started below it and then crossed it over time, and basically their original rights existed, but only at the point that it came up to renewal or a new lease did the new rights, the new status quo, kick in. But as I said, that is a bit of a grey area because there isn't a case that I'm aware of anyway, where that specific situation has occurred. Ultimately, you would be looking to ensure that for that fifth premises that you'd acquired, obviously, if it was leased already, that status would continue. Then at the point of the next renewal or the new option being negotiated, then you've got to add those additional compliance items. Just checking how we're going for time. So pending another question, I'll just raise another point of clarification with the 3-story rule. So just be aware with the 3 stories where the Act doesn't apply above those 3 stories. It will continue to apply if there is a retail shopping centre. So if you've got, as I don't know of any examples, well, I suppose there's a few in the city that are easy examples that are shopping centres of more than 3 stories, the Retail Leases Act will still apply in that scenario where you've got a shopping centre and it's going 4, 5, 6 stories, etc. Obviously very common throughout Asia, and as we get more dense as a nation, you'd expect more and more of that. So the Act will still apply in those situations, as well as for the sale of goods above the 3rd story. So really with the ministerial determination that addresses that, it's very much focused at services. So if you have, for example, an engineering company who's providing consulting services from the 6th story of a building in the middle of Dandenong, ultimately in that sort of scenario, the Act wouldn't apply, and obviously more favourable for the landlord that in that situation. And another thing we're running into a lot of lately, requests for solar panel installations to go into industrial and retail spaces as well. Solar panels going onto the top of sort of retail shopping strip sort of stores. Those are certainly raising some issues in terms of what's going to happen at the start, who's bearing the responsibility. We've certainly had some matters where damage has happened to premises because the solar installers have gone on, perhaps not been as careful as they should have been, and damaged roofs, damaged structural elements, or pierced waterproofing membranes. So it's very important to make sure that liability for that is clearly the tenants as part of any consent, and you've got indemnities in place. Also important to make sure that your insurer, from a landlord perspective, is aware that that's happening, because obviously that's a substantial change to the premises. There's also practical issues with the electrical systems, because the solar system isn't just the panel that's sitting on the top, it's obviously the inverter hooking into the electrical systems of the building. Are you, as a landlord or from a tenant perspective, are you making sure you obtain certificates of electrical safety to make sure that everything is done safely, for one? Secondly, from insurance perspective, that there's no easy out for an insurer, be it a landlord insurer or a tenant's insurer in terms of contents, where those safety steps haven't been done properly. And then what's to happen to that solar system at the end? If a lease runs for 15 or 20 years, is that solar system actually going to be of any value? Would it be better from a landlord perspective to require the tenant to make good, remove it, reinstate everything, fix the electricals back to its original condition? Obviously, there's a sustainability consideration there, but practically from the landlord's perspective, don't necessarily want to be inheriting that sort of asset. From a tenant perspective, obviously, there's going to be that cost involved of stripping it all back at the end, and then creating another risk situation where there's people up on the roof of the premises doing work and possibly causing damage. That sort of scenario. So yeah, something that we're running into a lot more of, and I suspect obviously more and more so as solar systems start to dot the roofs all over Australia. Again, pending any other questions, linking into one of Crystal's points in terms of licensed premises and partial use. We are seeing deals negotiated along those lines where perhaps not all of the premises can be used at the beginning. The winery example is one where we were acting for a tenant in that scenario, and they were about to set up a winery in country Victoria. But licensing will take a bit of time. There's a few months. Their lease ended up being conditional, I think, on 6 months for permits to be obtained, but they wanted to really get in there and start their operations. They already had other manufacturing sites and contacts with other manufacturers, and had product that they needed to store. And from the landlord perspective, obviously very handy that they could at least get rent, even if not all the rent, started at an earlier point. Yes, the lease was still conditional on getting the winery permits in place to be able to manufacture. But ultimately, when in this case, we were talking about a fairly large warehouse on a farming property that had effectively limited uses it could be applied to, at least that meant the income stream could get started earlier. And obviously the relationship between the parties could kick off, and income come in for both sides at an earlier point, rather than just sitting down waiting till councils work through its permit processes. And similarly with industrial properties, where there might be agreements to lease in place for the construction of factory premises, there could still be an initial lease perhaps for a yard if there's value to a tenant in terms of using part of that premises for storage of vehicles, heavy equipment, that sort of thing, or containers for that matter. Obviously bearing in mind some risk issues with that alongside the construction of a place. But if there is a large enough block that's being developed, and you've got that possibility of use of one part of it without impacting the construction on the other part, that's something to consider, which is of use for both a landlord and a tenant perspective. And then I don't think we've got any questions yet. So one last point in terms of options to purchase. Something we're seeing, well, both options to purchase and rights of first refusal, something we're seeing a lot of in the industrial space that's really been growing a lot in the last few years. As I'm sure many people are aware of, there's just not enough industrial land throughout the outskirts or generally throughout Melbourne. So we do have a lot of tenants who are wanting to secure for themselves their premises longer term. And with the variability in pricing, because of where the market's at, it is open to you in an option scenario from a landlord perspective to be not necessarily agreeing to the price at the outset, but trying to establish processes, whether it's 1 or 2 or 3 valuations, getting processes in place to determine a correct market value so that you're ensuring that once the option is exercised, it's actually a fair reflection of what something is worth. We've seen things, I guess, cut both ways where prices have been agreed and maybe not been reflective either of a market situation or of something else that had happened or was happening to a premises that would have affected that value. And once things are in the lease, it's obviously difficult to unwind. So once there's a particular value that's in there, everyone's pinning their position on that. It becomes a lot harder to be saying, well, hang on, that's not what I actually meant. And you're trying to undo the documentation. It's never a good thing. So always best to try and, if you are not wanting to agree with that level of specificity at the outset, the price is X bucks, let's instead put in place a mechanism that will find that market value. And if there is supposed to be or intended to be commercially a level of price adjustment, for other factors, because there are maybe externalities that are applicable to the premises or value add that's happening from the tenant perspective that is impacting the value of the premises, and the tenant doesn't want to get punished for its own, I guess, value improvement of the premises. Those are things that can be written in by way of factored adjustments, and again, addressed into valuations. Not the greatest certainty, obviously, for all sides, but that flexibility is certainly better than the parties, I guess, going at it at 20 paces because they have agreed prematurely on a price that wasn't reflective of what they had actually intended it to be, maybe a year, 2 years, 3 years before the point the option is exercised. So we are seeing a lot more of that, and then the flow through of that, where there are disputes coming down the track because people are arguing the terms don't reflect what they'd actually intended, despite the terms appearing to be expressed on their face. So unless anyone's got any other questions, I might just hand back to Mitch there for our wrap up.
Thanks, Andre, and thanks, team. That was really good. And I think it's pretty clear the matter, what the type of premises or whether you're a landlord or tenant, how complex some of these discussions and the importance of having these discussions at the beginning of the lease will be. And often we see with leases the temptation just to use a standard form, sort of tick the box type lease, but there's obviously a lot of opportunities to negotiate special clauses and things to suit the particular situation, and you could be cutting yourself short if you just rely on the standard provisions. We do have some more information on our website in this area on things like make good obligations and renewing leases, ending leases early, those sorts of things. And the team are always adding to that library of articles. And as we publish new ones, we push them out through LinkedIn, Facebook, and so on. So if there's anything in particular that you're thinking about or have queries on, go for the website and have a look at the articles on there. And of course, feel free to get in touch with us and put our details up at the end of the slides. Before we wrap up, just about at the end of the session, so a quick plug, if you'll allow me, for David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger. Really good workbook and handbook if you're looking for some guidance and thoughts from David on driving business excellence from a systems-based point of view. Lots of learnings and experiences from David as well, lots of templates and tools and resources that we've contributed that have helped us in our own practice and are easily adaptable in your own. So recommend checking that out on the website if you're interested, and that can be in hard copy and also available as an ebook. And that does bring us to the end. So thank you very much for joining us, everybody. As I said, feel free to get in touch with any of the team from time to time if you do have any questions. Always happy to be used as a sounding board and to bounce things off of us. And if we can be of help at any time, do get in touch. In the meantime, wish you all the best and hope you have a great day. Thank you.